Welcome to the Law Society of New South Wales Appropriate Workplace Behaviour Training. This video has been designed to ensure all employees of the Law Society continue to have an understanding of the appropriate workplace behaviour policy and the legislation and regulations that apply in New South Wales. In this video, you will be reminded of the Law Society's appropriate workplace behaviour policy and learn how to apply the policy principles in your day-to-day conduct. It is a condition of your employment that you abide by this policy. What is appropriate workplace behaviour? Appropriate workplace behaviour laws in this video mean the laws that create rights to be treated without discrimination and with respect. These laws apply to a range of environments. Specifically though, as far as your work is concerned, they apply to employment and pre-employment, contractors and service providers, volunteers and other persons in the workplace, employment, pre-employment elements. Inappropriate workplace behaviour can arise in any work relationships, including full-time, part-time or casual employees, contractors, volunteers, managers and staff, all of who are referred to in this video as workplace participants. Appropriate workplace behaviour laws also cover job advertisements, applications and recruitment, terms and conditions, promotions and transfers, training and dismissals. Your rights and obligations. There are Australian appropriate workplace behaviour laws in each of the states and territories. For the purpose of this video, you need to be aware that there are appropriate workplace behaviour laws that apply to you in your workplace and in other areas of your public life. You have the right to complain if you are subjected to discriminatory treatment or inappropriate behaviour at work. If you engage in conduct that breaches appropriate workplace behaviour laws, you could be held personally liable. Appropriate workplace behaviour concepts. There are 5 important concepts that we will cover in this video. Discrimination, harassment, sexual harassment, vilification, and bullying. Let's deal with each one in turn. What is discrimination? Discrimination occurs when a person is treated less favourably in their employment because they have a certain characteristic that is protected by law. Discrimination generally arises from stereotypes or assumptions about a person who has that characteristic. There are a number of protected characteristics under federal and New South Wales laws, including the following: sex, age, marital, domestic, relationship status, religion, HIV, AIDS, carer, family responsibilities, political opinion, sexual orientation, preference, gender identity and intersex status, pregnancy, including potential pregnancy, and breastfeeding, disability, including physical, mental, and intellectual disability, race, including colour, nationality, descent, ethnic, ethno-religion, or national origin. These grounds apply whether the person has the characteristic now or had it previously, or whether they are presumed to have it. Discrimination may also occur where there is a condition, requirement, or practice which appears to be the same for everyone, but in fact disadvantages someone with a protected characteristic, and the condition, requirement, or practice is unreasonable. A person can unlawfully discriminate against another person even if they did not intend to do so, if they treat that person less favourably because of these protected characteristics. Unlawful discrimination can arise in a number of areas in individuals' working lives. Examples include failing to offer training to an older worker because you assume they will retire soon, failing to give a female employee a promotion because she has children or is pregnant, excluding or isolating a person because of their religion. What is harassment? Harassment is a form of discrimination. It may consist of unwelcome, offensive, belittling, or abusive behaviour towards another person because they possess one of the protected characteristics. For example, harassing someone by making an insulting joke or derogatory remark about their race, age, religion, sexual orientation, or disability is less favourable treatment of them than someone who does not have that characteristic, and therefore constitutes discriminatory treatment. Harassment does not have to be directed at a particular individual to be unlawful. Behaviour which creates a hostile working environment for other workplace participants can also be unlawful. The fact that no offence was intended or that the behaviour was in jest is not a defence. Examples of harassment in the workplace include racial or culturally insensitive jokes or nicknames, offensive comments about a person's sexuality, and teasing a person about their disability. What is sexual harassment? Sexual harassment is unwelcome, unwanted, or uninvited conduct of a sexual nature that makes a person feel offended, humiliated, or intimidated. Behaviour can amount to sexual harassment even if the person did not intend to offend. For example, because they were telling a joke. However, conduct will not be sexual harassment if a reasonable person would not have anticipated the possibility that conduct would offend, humiliate, or intimidate the other person. Sexual harassment is not behaviour which is based on mutual attraction, flirtation, or friendship. If the behaviour is consensual and reciprocated, it is not sexual harassment. Examples of sexual harassment can include physical, intimate physical contact such as pinching, touching, grabbing, kissing, or hugging. Sexual assault. Non-physical, staring or leering at a person or at parts of their body. Persistent requests to go out where they are refused. Suggestive comments about a person's body or appearance. Sexual jokes or comments. Sexually explicit conversations. Displays of material containing nudity, semi-nudity, or otherwise of a sexual nature such as posters, photographs, calendars, screensavers, etc. Viewing, accessing, downloading, or transmitting nude, semi-nude, sexually explicit, pornographic, or other material of a sexual nature using the internet or social media. Sending sexually suggestive or explicit emails, attachments, or text messages. Sexually explicit gifts, for example, Kris Kringle or birthday gifts. Both men and women can experience sexual harassment at work. Same-sex harassment is also covered. Often, sexual harassment involves a pattern of unwelcome behaviour. However, one act is sufficient to constitute sexual harassment in some circumstances. Sexual harassment does not have to be directed at a particular individual to be unlawful. Behaviour which creates a sexually hostile working environment for other workplace participants can also be unlawful. For example, overhearing a colleague talk about sex, telling sexual jokes, or making innuendos. In some circumstances, workplace participants can be individually sued for their behaviour and comments and ordered to pay damages. Physical sexual harassment can constitute criminal conduct, such as assault and indecent exposure. What is vilification? Vilification is a public act which incites hatred, severe contempt or severe ridicule of a person or group because of race, homosexuality, transgender, transsexuality, or HIV/AIDS. A public act can include communication to the public in the media or on the internet through social media platforms. Serious vilification, threatening, or inciting physical harm to a person or group because they possess one of these characteristics is an offence under New South Wales laws and will be dealt with accordingly by the Law Society of New South Wales. Examples of vilification can include sending a group staff email containing a highly offensive racial joke, making derogatory comments about gay employees in front of a group of employees or through social media. What is bullying? Bullying is a repeated, unreasonable behaviour directed towards an individual or group that creates a risk to health and safety. Bullying behaviour may also be workplace harassment, based on a person's protected characteristic such as race, sex, age, etc., and/or sexual harassment, or it may simply be based on a personal dislike or animosity. A person can be bullied for any reason. It can occur between a worker and a manager, or between co-workers, colleagues. Unreasonable behaviour means behaviour that a reasonable person, having regard to all the circumstances, would expect to victimise, humiliate, intimidate, or threaten another in the workplace. Bullying may be perpetrated by a colleague or colleagues, a manager, or even a client. It includes behaviour that degrades or undermines others in the workplace. For behaviour to constitute bullying, it must be repeated. A one-off incident would not normally constitute bullying, although single incidents may still present a risk to health and safety. There is no requirement that the person deliberately or intentionally meant to bully the person. However, intention may be relevant in assessing the severity of the conduct. Examples of bullying behaviour include physical assault or threats, initiation rights, abusive, insulting, or offensive language or comments or name-calling, deliberately withholding important information vital for effective work performance, teasing, humiliating comments or practical jokes, intimidating actions, deliberately excluding or isolating someone, ignoring them, rumours, gossip or innuendo, belittling opinions or unjustified criticism, particularly where communicated in front of others, encouraging other employees to participate in the bullying behaviour, aggressive behaviour such as shouting, yelling, throwing objects or slamming doors, and allocating meaningless or impossible tasks to carry out. What is not bullying? Differences of opinion and robust debate are not bullying. Neither is interpersonal conflict, although conflict that is not resolved may escalate into bullying and should therefore be resolved wherever possible. It is not bullying for a manager or supervisor to counsel a workplace participant about their performance or conduct in a reasonable manner. Performance management and/or counselling are a necessary part of ensuring that workplace participants meet required standards of work and behaviour. While receiving negative feedback may be stressful, it does not in itself constitute bullying. Provided they are carried out in a reasonable manner, other examples of reasonable management action include transferring, for example, to another role or department, demoting, counselling, warning, disciplining, or dismissing an employee, setting performance goals, expectations and deadlines, refusing requests or making decisions not to provide a benefit, issuing work directions and orders, and allocating work tasks consistent with business needs and systems. What is victimization? So far in the video, we have covered off 5 key appropriate workplace behaviour concepts. It is important to note that you cannot discriminate against someone because they have sought to protect their rights under appropriate workplace behaviour laws. Victimization is where a person is retaliated against or treated detrimentally because they have lodged a complaint, they intend to lodge a complaint, or they are involved in a complaint of unlawful conduct. If a workplace participant feels they have been subjected to unlawful conduct, they are encouraged to raise the issue using the Staff Complaints Resolution Policy as outlined in the appropriate workplace behaviour policy. The Law Society of New South Wales will not treat a workplace participant less favourably in their employment because they have made a complaint. Further, workplace participants must not retaliate against a person who raises a complaint or subject them to any detriment. However, where a person lodges a false complaint in bad faith, that person may be disciplined. Examples of victimization may include excluding or isolating a person because they have lodged a complaint, failing to promote a person because they have lodged a complaint. Overview of your responsibilities. Appropriate workplace behaviour laws and the Law Society's appropriate workplace behaviour policy are very clear about how you and your colleagues are expected to behave at work. Whatever your personal views might be, you are expected to contribute to a workplace that is free from discrimination, harassment, sexual harassment, and victimization. Where people are able and encouraged to speak up if they feel they have been discriminated against or have been subject to other inappropriate workplace conduct. Where employees who raise an issue feel confident that the matter will be dealt with in a professional manner by both fellow employees and management. Responsibilities of workplace participants. All workplace participants are required to maintain confidentiality if they are involved in a complaint procedure. If a workplace participant breaches confidentiality, they may be subjected to disciplinary action. Spreading rumours or gossip may also expose workplace participants to a defamation claim. Workplace participants should be aware that in some circumstances, they can be held legally responsible for their own unlawful conduct. Workplace participants who aid, abet, or encourage other persons to engage in unlawful conduct can also be legally liable. If you observe someone else at work being subjected to unlawful conduct or conduct that is potentially in breach of the Law Society's appropriate workplace behaviour policy, you are encouraged to report this conduct, particularly where it involves serious harassment or bullying that creates an unsafe work environment. However, it is not your responsibility to confront the alleged harasser or bully. Breach of the Law Society's appropriate workplace behaviour policy. All workplace participants are required to comply with the Law Society's appropriate workplace behaviour policy at all times. A reminder that the policy can be found on the Staff Policies and Procedures page on the intranet. If an employee breaches this policy, they will be subject to disciplinary action. In serious cases, this may include termination of employment. Agents and contractors who are found to have breached this policy may have their contracts with the Law Society of New South Wales terminated or not renewed. What should you do if you have a complaint? If you feel that you have been subjected to any form of inappropriate behaviour in breach of the Law Society's appropriate workplace behaviour policy, you should not ignore it. So, what are the appropriate actions to take? Step 1 is to confront the issue. However, this is not a compulsory step. Step 2 is to report the issue. Workplace participants are able to obtain professional, confidential support by accessing the Law Society of New South Wales Employee Assistance Program. This is a confidential service, and details are not divulged to the Law Society of New South Wales. Contact details for this free service are available on the intranet or from managers and the Human Resources Department. Conclusion. This concludes the appropriate workplace behaviour training video. During this video, we have looked at why it is important to be aware of the Law Society's appropriate workplace behaviour policy to ensure that you and other Law Society staff can make a valuable contribution to create a respectful and productive working environment. We have also considered what to do if you have a complaint, including reporting the issue under the Law Society's complaint resolution policy. We hope you have gained valuable knowledge to assist you in your role at the Law Society. If you have any further questions in relation to appropriate workplace behaviour or this video, please contact your manager or Human Resources.